It's just a complete, total failed presidency. It's like, how do you just say that stuff? How do you just say that in the face of everything that's going on?
Yeah.
What a miserable, low-life, evil.
Right.
When people lie that much, it's just plain evil.
Yeah, I agree. And just like that, we made it all the way back to Friday with Stan Pierchoski.
We did. Good morning, Jeff.
How are you? How are you?
Pretty good. Pretty good for a Friday. So
Yeah.
far, I can say so far so good.
What's the weather like out there this morning?
It's a little overcast, but I don't know if it's going to rain or not.
Yeah.
I did see a little sprinkling early, about an hour or two when I first got up. I saw a little sprinkling.
Still dark when I got to the studio here, and so I haven't been back out.
Feels a little humid, so that tells me there's probably a chance of rain. But I really didn't check my app or I didn't listen to any news. I didn't hear any on the way over either. So
Well, you probably had a busy week.
it was a very busy week, as a matter of fact. As a matter of fact, last 2 weeks were pretty much when we had the seminar here back in May, when people that wanted to engage and set up meetings with me, we pretty much had most of those last week and this week.
Yeah.
A lot of people wanting to protect their property.
Well, if you're new to the program here on Fridays, this is Stan Pierchoski, Pierchoski Estate Law, and we do bulletproof estate planning, or he does rather.
We do.
And I get to talk about it with him here on Friday mornings. So, and of course, the phone lines are open for you too, 766-9393. We'd like to make it interactive for you, and while we are live. And Stan, you're always informative, entertaining, and we've had lots of good discussions over the last, couple of years now.
Yeah. I think there's been two come around, well, about now, around June. I think it's been two, yeah.
How about that? Time flies.
It does, doesn't it?
Time flies.
I had a client come in and visit with me, and he said, hey, I ran into Jeff Hood, and I told him, hey, I like listening to your show. Did you remember somebody asking you that?
Oh, yeah. I have it all the time.
Yeah.
Yeah, I do. I have it all the time. People tell me that they listen in and enjoy the show. Not only yours, but others, but this one in particular.
I hope that people are learning from some of the stuff we talk about. It's good information, and it's information that's hard to find the real truth about some things.
Yeah.
I'm not bashing the internet, but you know how the internet is. It's wide open. It's not really controlled as far as what information people publish. And there are, not just this subject, but others. But when people publish stuff on what I do, estate planning, it's not always correct. Now, when I say that, it's usually not 100% correct. In other words, there's obviously some truth in there, but it's not all there.
Right.
Because I was going to talk about this morning. But people tell me all the time that if you have to spend down your assets. If somebody's going to the nursing home, you got to spend down. You got to spend down. Okay. Now there is such a thing as a spend down, but it's not the way they portray it. It's not like just going to spree and dump all your money, which is what the street vernacular approach is. Or they'll say, you got to get rid of all your money because you're only allowed to have $2,000. Now there's just a glimmer of truth in there. Like the number's correct, but it's not exactly the way it works. It doesn't mean $2,000 to your name. It means a certain kind of $2,000.
Right.
So once you understand what actually happens, your spirits will lift and think, wow, we do have lots of options and stuff. But I want to talk about a couple things.
Sure.
This morning. One, I want to talk about, we do a lot of 10-care eligibility. And we do trust planning. And one of the asset protection trusts that we do is kind of preparing your assets to be protected if you go into long-term care. It's really a trust planning for distribution after death, but it also has the effect of if something happens to you or your spouse or you in long-term care, it comes up in the picture, it will give you the protection of your property.
Right.
But it's something you do in advance of going into care. But we also do this stuff when people are actually in care, kind of like we did with your father-in-law.
Yeah.
When you're actually in care. And I've got a facility that I have a client over there that we've been working with almost a year now. I mean, we have like 3 appeals so far. So far, I'm holding my own. We're winning all the appeals, but I haven't got the approval yet.
Yeah.
And that will come. It always does. Well, it's not as long as the longest one I've had. The longest one I had was almost a year and a fourth, about
Wow.
a year and 3 months. But on that case, I got the approval I wanted that dated all the way back to a year and 3 months ahead of time. Gave me exactly what I wanted if they would have just approved it in the first place. But they were being stingy, and we had to go through several appeals, and We were successful with all of them, and we'll be successful with this one. But when that happens, the facility, and this facility is kind of in the same group as people that just look at the internet, and they don't understand the workings of it. I mean, now they take care of people, and I'm not talking about the care that people get.
Right.
I'm talking about the administration and the following of the 10 care laws and stuff like that.
Yes.
And here's where I see the problem. You know, when facilities agree to take a 10 care patient, or if, you know, there's not too many facilities out there that will only, they say we don't take 10 care, we only take private pay. You can do that, but most of them don't, because a majority of people either are on or end up on 10 care, and they want to get paid, right?
And the majority of people simply can't afford to self-pay.
Exactly, or at least for any length of time.
Right.
Now, when you agree to take 10 care patients, but what maybe they don't get is they agree to take all the rules that go with that.
Yeah.
And there's a lot of them. And I often find out, not all of them, some of them have a good understanding. Some of them call and ask me to help them understand how certain things work.
Sure.
And I welcome that. When somebody's trying to get eligible, sometimes it feels adversarial between me and the facility, and it shouldn't be, because I'm trying to get them paid. You know, the whole eligibility process, we are working for one and the same goal. I'm trying to get them paid, because when you talk about long-term care, the question is not whether the facility gets paid. I would never advocate that they don't get paid, because they provide a service, like any business, they provide a service, they should be compensated. Right. The question is who pays them. It's either the person individually or the 10 care program, right? But they get paid no matter what, and that's what we do. But sometimes I get a little bit sideways with them, or vice versa, because they don't understand what I'm doing, and it looks, you know, they interpret it as I'm trying to keep them from getting paid, and I'm not. And I have a facility right now that's acting that way, and they're, you know, because of this case I have there that's been going on for years, still not resolved. Okay.
Right.
So they sort of take the position, well, this thing's been appealed, must have did something wrong. 10 care has denied them a couple times, but I've won every appeal so far. But they don't get the whole picture of what's going on, and so now they're worried, because now to them, if it doesn't go through, then the private pay goes back to the day we filed the application, and this is what I'm talking about, almost a year, right?
Yes,
you know,
and this would be thousands of dollars.
$80,000.
Yes.
And so they're a little bit nervous about that, and I get it, I understand that. And now, well, just like I tell people, I'm not allowed to promise a result or guarantee a result. No attorney is allowed to do that. But I can talk about my track record. Okay, my track record is that I've never failed to get somebody eligible that has hired me.
Yes.
And I'm 100% successful in my fair hearings. You know, so so far so good. Will this be the first time?
That's a pretty good record.
Will this be the first time we lose one? I don't know. I guess it's possible, but I don't think so. I feel very confident in our position. I've been in this position before and been successful. I'll be successful in this one too. So it's coming. But now I have another client that recently hired me that is in the same facility. And what I'm running into is the people at the facility are somewhat tainting my image with the new client, because it's like, well, you know, we got this case and we're worried maybe he's not doing things right, something like that. And I'm trying to deal with it gingerly, because I understand where they're coming from.
Sure.
I don't like it, but it has not really happened before to this extent.
Right.
And so, you know, I'm certainly going to approach them and just say, look, if you have any, what really concerns me is they haven't called me. They talked to my client, and now my client is worried, because they think they're going to treat her mom different because of the attorney they hired. Now, here you exercise your absolute right to hire an attorney to represent you in some matter.
Sure.
And it seems like they're getting badgered for doing that. So I have some remedies available to me, and some administrative that I'll deal with first before I pull any triggers on anything harsh. But I mean, it needs to stop, because it's creating tension among the
a lot of angst.
Well, the family. I mean, they're tense about the whole thing.
Sure.
And I assure them that, you know, there's nothing they can do from a care standpoint. You know, as a matter of fact, it's an absolute law that a 10 care patient receives no less quality of care, than a private pay person.
Yeah.
That's a common misunderstanding. People say, if you're private paying, you're going to get taken care of better.
Yeah.
But it is a serious crime to treat a 10 care patient differently than somebody who's private pay.
Yeah.
And it makes sense that it would be so.
Sure,
right? You know?
absolutely.
So, but it is a real crime, and if anybody out there thinks that's going on, you know, there's some organizations called the 10 Care Ombudsman, and they have different districts throughout Tennessee, and they will look into that in a heartbeat. If you know, now you may think that's going on, you can report it, they'll look into it, and if it's not going on, they'll come back to you and say, no, we don't see the evidence of that, or if there is evidence of that, that facility jeopardizes their ability to have any TennCare cases.
Yeah.
And those are the triggers I can pull, which I don't want to, but I'm gonna approach them and say, look, if you got a concern, why don't you come to the horse's mouth and ask, and I'll explain to you what I'm doing, why I'm so confident in my position, how, why we're going to be successful. I'll point to the rules, and I'll point out the authority that supports my position 100%. I just don't wing it. I just don't say, let's just fill out this application and see what happens.
Yeah.
It doesn't happen. I mean, if I fill out this application, if there's something in there that says we're not eligible, we don't file it until we fix it. And when you are eligible, then I'll file the application.
Yeah.
And I don't mean spend down and spend all your money. I mean change it to a non-countable asset that's not part of the eligibility calculations. We talked about it a lot of times. So
absolutely.
This is an area of law, and I've said it before, that for some reason I think if there's ever a need for people to have an advocate, it is in this area of law.
I would agree.
Because there's misinformation, and sometimes when the misinformation comes from a source where people think should be in the know,
sure,
like the administration of a facility, you would assume they know and understand how it works.
Sure.
Some of them do, but I'm telling you, some of them do not.
Yeah, yeah.
And I don't know if it comes from just not knowing or if they're trained that way. I don't know. I'm not a fly on the wall. But I try to set the record straight. I keep them notified of everything. I tell them in my letters when I notify. And I always notify them by written letter so that they have a record. And I explain exactly what we're doing and where we are in the situation. Try to ease their tension because TennCare sometimes pushes back.
Yeah.
I mean, let's face it. We're trying to get TennCare to pay as much as they can, and they're trying to get you to pay as much as you can. It's an adversarial system, and that doesn't surprise me. But we play squarely in the rules, and that's why we're so successful. I mean, it's when you shoot from the hip that things don't work right.
Yeah. I had a thought, Stan, as you were talking about that, and it just dawned on me. You're dealing with people and circumstances, and sometimes difficult circumstances for families, and we've had our own experience with you and with that. And someone in your position, you have a great comfort level because of your experience and expertise in this area, and so you don't have the stress personally. You don't have the stress personally. So, and when you're dealing with a family, and I remember on our circumstances, Teresa was stressed to the max, and there's a difficult gap to reach for someone in your position to bring a comfort to that family and that person and say, look, this is how it works, and this is how I know it works. And I run into that with real estate too. People have families, they're stressed over this because they don't do it all the time.
Exactly.
And so could you expand on that and how you have
I sure will.
Because it's kind of an interesting thing.
And like you said, you probably experienced the exact same thing in real estate because the stakes are kind of high.
They are high.
We're talking about the high cost of long-term care.
Right.
When you're talking about real estate, it's typically hundreds of thousands of dollars of value in a house or anywhere to.
And they don't do it all the time, but you do.
But that's enough to stress somebody out.
It is.
Because human beings have doubt. They just what I mean. And you run to doubt without even thinking about it.
Right.
That's like the animalistic response to something is you run to this doubt. And so, here's some of the positions I'm in that I have to get past. I warn people ahead of time. I say, look, TennCare often, I'm not going to say 50% of the time, but a little more often than I would expect, will deny an application. And now, that's stressful.
It is stressful.
Okay, we hired, Mr. Stan, we came here, we hired you, you got all this information, you filled out the application, you filed it, now they said no. And so I have this conversation ahead of time. I said, look, this can happen. It's not unusual that this will happen.
That's right.
And I said, but here's the way I do it. I will not file an application until the person is 200% eligible. Now, if that's the case, I mean, there's absolutely no error, no room for error in my application. Which means when they deny, I know before I even know the reason they denied it that it's inappropriate.
Yeah.
I mean, I understand it to that level because you can't do what I do without understanding it to that level.
Yes.
And so when we find out what the reason is, because sometimes they just deny and don't say why, which is really kind of a rotten trick to do to somebody. In an adversarial system, you always got to disclose to the other side your position, right? I mean, you don't play hide the ball, and they just won't do it. So I'll call them and ask them, and usually they'll give me some hint. Sometimes I can tell by the language in the denial where they're leaning,
Yeah.
And then I'll find out what it is, and I'll know what they did wrong.
Yeah.
And I'll try to negotiate with, but I got to go to the family and say, look, they denied, but it's like, don't worry, I'll win on appeal, and that may not be much comfort to them. You know, so
Yeah.
I kind of warm them up that ahead of time, and but when I do win on appeal, then it's like, Mr. Stain can do no wrong. You know? But I tell them, I say, look, it could be rocky for a while. I just don't know. Some just go through without a hitch, and then you have one that doesn't have. Sometimes I have one that's a complicated case, and I'm thinking, you know, they'll probably balk at this a couple of times, and it'll slide through. Then you have one that's, I think, this is perfect, everything's in place, it should slide right through, and it doesn't. It's just the inconsistency of it sometimes gets a little frustrating to me. But I know it's going to happen, and so I approach the family and I say, you know, this can happen, but you just bear with me, and I try to explain to them why. And when I explain to them why, they feel a little bit better about it. And that's why we win on appeal. I mean, that's why people fail with the do-it-yourself application. Because I think if they know it's a do-it-yourself application, I think they're probably more likely to deny. Now, I don't know, I can't confirm any of that.
Right.
Because let's think of it this way. If they deny your appeal, if they deny your application, you have a right to a fair hearing.
Yeah.
That's an appeal process. How are you going to win a fair hearing if you don't know what they did wrong and don't know what they should have done, what the right thing is they should have done, under the rules and the authority?
You don't know why they've turned it down.
Well, I mean, even if you know why they turned it down, you have to know that that's a wrong reason, and you have to know what they should have done that was right, that would have actually resulted in approval.
Yeah.
And that's how you present it to the court. And if you back that up with the authority that shows they did it wrong and shows what they should have done, and if they had done it right, it would result in approval. I mean, you back the court in a position where they have no choice but to rule in your favor, because that's the rule.
Yep.
So that's why we have such a success rate doing that.
Yeah.
And that's why I operate that way. It takes a little longer to get the application. Somebody comes to me and they're already in and they're paying. It's like, hurry, 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 file the application, so we only have to pay the estimated liability for, we get that special status.
Yeah.
And it's like, sometimes I can't just hurry. There's a few things I got to clean up before I can get there. So, there's that. But then I have to combat the facility telling them things that aren't right.
Yeah.
I mean, a classic example is sometimes, almost all facilities think this, but they'll tell somebody, okay, if you want to file for TennCare, don't worry about your home. Now the home, as I refer to, the primary residence. You can have primary residence, then you can have other real estate, okay?
Yeah.
They're not the same, but the primary residence, they say, don't worry, your house is protected.
Yeah.
There's no problem with that. And that makes people feel good, but the house is not protected. I mean, let me put this, word protected is not the word I would use.
Yeah.
It's more of like a deferral.
It's deferred.
They won't take it, they just won't take it now.
Yeah.
I mean, I'm serious about this. There's no
agree.
such thing as protected on the primary residence. As long as I brought it up, we might as well walk through this. The primary residence is what they call an excluded asset. You have countable assets, you have non-countable assets, you have inaccessible assets, several categories of asset. Well, you can have exempt, which is kind of like in tax law, or you can have an excluded asset. Now, excluded asset is a unique asset.
Yeah.
So your primary residence is an excluded asset, right? But your primary residence is a countable asset. It's considered available to you for the cost of care. However, they're not going to make you sell your house where you live, your primary residence, to pay for your cost of care, because they will put it down as an excluded asset, which means they're taking it out of the countable column and putting it over here in the excluded column, right? It's still a countable asset, but they're taking it out of your countable assets, so when we figure out how many countable assets you have and are you eligible, this $300,000 house is not in there.
Right.
Because if you have a $300,000 house and you can only have $2,000 of countable assets, the house puts you $298,000 over resourced, does it not?
Right.
And so they take all that out. And now what happens? You go in now maybe you're eligible, and you go into the facility. You're there for average 3.6 years. You pay $100,000 a month, and you rack up a $400,000 bill, right?
Right.
At your death. Now it's different with a couple, but at your death, they will exercise the TennCare Estate Recovery Act, which means they can go after. Now they're saying, we paid $350,000 for you over these years. We want paid back.
Right.
And they only get what they put out. They don't get anything more than that, but they get what they. And so they go after anything that's in your estate.
Correct.
Now remember the house. It didn't go anywhere. You still own it. Your name is still on that deed. The excluded part of it means they just didn't use it when they determined eligibility.
Right.
It wasn't in the equation but it's a countable asset, and at death, the estate recovery in Tennessee says it's fair game for us to go after it.
Right.
So I don't call that protected. I call that kicking the can down the road, but they're going to get it.
Yes.
Now, we have a way to stop that and protect the house, but you have to do something, and you have to do it at the right time. That's one of the things we do that has a timing issue to it. But if you do it at the right time, we can completely protect the primary residence.
Right.
There is a way around that. But if you don't do anything, and you just rely on the facility or whoever else, whether it's somebody on the internet saying, don't worry, your house is a protected asset.
Yeah.
I don't like that word. I object to that term. It's misleading.
Yeah. Yeah.
And
yeah.
it makes you think, it gives you this false sense of security, and then your heirs, after death, thinking they just inherited the house, then every probate case has to file a 10-care release, and then you find out they got a $300,000 claim on a $300,000 house, and it's, and God bless 10-care, they will let the heirs buy it back, because they don't really want a house, they just want their money.
Right.
So, now, if you're married, it's a little different. It's the same, except, God bless them, they will not take the house if you still have a spouse living in it at your death. So
But it still has the lien.
So Jeff goes in a nursing home, he passes away in a nursing home, he's racked up a 10-care bill.
Right.
Teresa's still the healthy spouse at home. They will not take your primary residence while she's living there. They will, like I said, God bless them, they will wait till she passes away before they take it.
Yeah.
But they will take it.
Yeah.
The lien, the right to go after it exists at your death.
Yep.
Even if, now this is another misunderstanding, even if you and Teresa own the house with what we call right of survivorship, you'd say, well, my death, it instantly vests with her. Not so, says the Tennessee Supreme Court. That is an indicia of ownership at death, and that's what creates, puts it squarely in the crosshairs of 10-care estate recovery. Now, it happens, but there's a way to fix that. We're probably a little involved for the radio show for the time we have left, but there's certainly a methodology to fix it. We do it all the time. And that's a big advantage if you can save the primary residence. Sometimes the biggest asset in the estate is the primary residence.
Yeah.
It's not unusual that that's the case. So, the misinformation that's out there is always kind of like a thorn in my side a little bit. It's always kind of a constant irritation that it's out there. And I have to battle that. I have to talk to people about it. I have to explain to them that, okay, I know what you've read, I know what you've seen, here's why that's not the way it works. And most people are open to that conversation. Some just, you know how some people think, well, I've never heard of that, so therefore it can't be.
Yeah, yeah.
And I
Never heard of that, so it doesn't exist.
You need to be a little more open-minded than that. There could be something out there you haven't heard of.
Right.
But, some of the folks that are old school, but most of them still come around too, because
Sure.
when they hear the things they never heard of, they're beneficial to them. So
Sure.
It's a little easier to open your mind to something that looks like it might be helpful to you.
Absolutely.
And that's exactly what it is. The thought about going into long-term care is the immediately jump to all is lost, they'll get everything.
Yeah.
It's
yeah.
all, they're gonna take it all, we are just SOL. And it's not that way, certainly not that bad. Now,
Yeah.
it used to be a whole lot better, but, they've changed things over the years. But what it is now is there's still quite a few tools that we can use, and we use them. We use every one of them. And it's okay to use them. Now, just like we talked earlier about the facilities and stuff, not knowing what I do or understand what I do.
Yeah.
And that just comes from them not understanding, because what I do is exactly what 10-care authority allows me to do. It's not like I make it up and keep a secret playbook. It's all squarely within the statutes. And I will, if they would ask, I'd explain it to them. But
Sure.
Unless they just want to trash me to my client when I'm not, and never call me, there's not much I can do about it. But it's like with 10-care especially, not so much the facility, but sometimes with 10-care, they know how it works.
Oh yeah.
Sometimes when they inappropriately deny, I swear it's just because they know they're doing it inappropriately. Like I said, I can't confirm any of that. I'm not a fly on the wall in 10-care, but it just seems to happen way more often than it should. And it seems to happen with the same issues over and over. So it's not like they get a memo and learn from their mistakes. It's like, I don't know. I just deal with it from my end, but it's full disclosure with them. And I've had 10-care call me and say, hey, why did, what happened? I see where there was some money taken out of this trust that these folks have.
Yeah.
And they said, so where'd that go? I said, well, I'm glad you asked. I'll tell you. We exercised our right of unlimited distribution of principal to our descendants, and we gave $20,000. The trustors gave $20,000 to their son.
Yeah.
And they say, oh, okay. And I say, and here's the place, look in the trust, turn to section 3.03 and read that with me on the phone, and you see where they have the authority to do that. Because it was principle, right? And they say, okay, I see where, then they'll say, well, what did son do with it? I said, well, you're not allowed to ask that, and I don't have to tell you, but since you asked, I'm more than happy to explain it to you.
Yeah.
The son took that money and bought that new wheelchair and gave it to his dad.
Yeah.
He said, well, isn't that the trustor getting the $20,000? I said, no, because if you read this court case, it says as long as the trust says no access to principal and you can't obligate these people to do what they do, the courts uphold creditor protection. So, there you have it. There's exactly what we did in a nutshell. It's 100% squarely within the rules and the court law that I follow. So, it's your move. What do you want to do? If you want to deny it, then this will all be brought up again at the fair hearing.
Yeah.
And when I talk to the judge, he at least understands law.
Yeah.
Whether you do or not, and you won't, I'm just telling you, just in that scenario there, I am 100% loaded for bear, am I not? I mean,
Yeah.
if you want to deny. Please don't. It'd be easier for all of us if you don't. But if you do, I will be successful.
Yeah.
This is what the law says I can do,
Yeah.
and I can support it. I can completely. Sure, here's what we did. Here's the authority we did it. Here's the either the statutory law or the common law, which are court decisions
Yeah.
that says I'm allowed to do it.
Yeah.
What are you going to do? Deny it?
Yeah.
When I get to another appellate court, they're going to hammer you. They
Yeah.
don't like you doing that kind of blatant
Wasting the court's time.
wasting the court's time. This is well settled law, and this is exactly what, don't bring this. They'll sanction courts for that.
Wow.
Higher courts will. If you ask for it.
Yeah. Interesting.
And so it's just misinformation out there.
But that's the one of those examples that causes the family tremendous stress. So you're managing not only the argument, but you're also managing the stress of the family, trying to ease them through this.
That's right. That helps. That helps. But I got a family like the one I was telling you that's been going on for almost a year, and bless their hearts, they tell me, they say, we trust you, Mr. Tan. We trust you. But they keep saying, any word on this appeal? Because we file an appeal. We perfect the appeal, and then TennCare has 90 days to tell us when the appeal is going to be.
Yeah.
And if it comes on day, it never comes before day 88 or 89. Because they know they got 90 days, which is frustrating. They could do it sooner. And then when they give the hearing date, it's usually about 2 weeks out. So it's usually not going to put it out forever. But I had a case a while back where I got to day 110, and not in silencio. And so I drafted what is called a writ of mandamus.
Yeah.
Under law, we have these petitions, and there are 4 extraordinary remedies. They're called extraordinary writs. One of them you heard of, called the writ of habeas corpus, which is I'm unfairly imprisoned, get me out of jail, right? Then there's a writ of mandamus, which commands action. You give it to a higher court to order the lower court to do something they're supposed to do, and they're not doing it.
Right.
Then you got a writ of prohibition. Writ of prohibition, which prohibits action. Okay. And if there's some action that's being done and you want it stopped,
Yeah.
The Greek, I'm drawing a blank on the third one because I don't think I've ever done the third one.
Okay.
Habeas corpus, warranto, prohibition, mandamus, quo warranto. Okay. That is a very unique one. I've never done the warranto. But those are extraordinary writs, which means you file them, whatever the court has on its docket. And you always go to the next court up for these, because this is when you're complaining about the lower court, okay? Not complaining about the case. You're saying the lower court's not doing what they're supposed to do according to law.
Right.
And so we have a case where they're supposed to tell me in 90 days, right? And on day 110, they haven't told me anything yet. Did they just get a free ticket to do that? I don't think so. My client's been waiting for 90 days. Now they're waiting 20 more. So, but if failure to act timely is fatal. So I act. And I didn't quite file it, but I wrote it and sent them a copy of it and said, listen, I want to know when that appeal is. It's day 110.
Yeah.
Here's the appeal. I'm filing it tomorrow if I don't hear from you today. I heard from them today. It was a writ of mandamus, and it goes to the court, and that court will force the lower organization to do what they have to do.
Oh, wow.
And and what I was saying, when you have an extraordinary writ, and you go to a higher court, whatever is on their docket, that gets the first thing they look at.
Really?
Supreme Court, the United States Supreme Court, every time they sit down and have a session, one of the first questions comes up is, do we have any habeas corpus?
Yeah.
Regardless of what we had planned to talk about, any habeas corpus for the court to decide, they would take that up first.
Really?
It's called the 4 extraordinary writs. They are special remedies that you don't put it off and say, okay, we'll hear this 6 months from now. So the person that's wrongfully imprisoned doesn't get heard for 6 months. And if you find out he's wrongfully imprisoned, now that's a problem. You know what I mean? You want to find out right away. So, but anyway, they wouldn't do that. And so I said, I'm going to file this like Friday. This was on Wednesday or something.
Right.
And I heard from them, and they gave me a date. Now, I should have done something to say, well, I shouldn't have had to wait to day 110, is what I should have done.
Yeah.
But pick your battles sometimes. I got my date. It was less than 2 weeks away.
Right.
We won the hearing. Could I have gone back and tried to hammer them for missing the 90 days, even though they fixed it after 90 days? Yes, there's something I could have done, but in one of these days I will, if it's egregious enough. You know what I mean?
Yeah.
One of these days I will.
Yeah.
Now, what have I done? Now they know when I call up and say, when's my hearing date? We're coming up on day 90. they say, well, who's making that? Who's asking that? Well, that's Pierchoski. And say, well, okay, you better. I know what he's going to do. You better give him a hearing date. So, should it be that way? No.
It shouldn't be that way.
It's kind of like our administration. Peace through strength.
Peace through strength. Yes.
Eligibility through strength. Give me what I want, or I'll make your life miserable.
Well, it's not just a matter
Give me
of
what the rules want.
It's not just a matter of giving what you want. It's a matter of doing what's supposed to be done.
Give me what the rules say we're entitled to, and I'll leave you alone.
Yeah, exactly.
I'm hired to do that for the country.
This seems to be maybe not in every state department, but we deal with state department ourselves. With regulation and licensing, all that kind of stuff. And we were waiting on a new license for a new agent, entirely too long, and we couldn't figure out why this was going on. And they said, well, it's just a process, and other licensees were coming and going, and we were still waiting on this one. So I finally made a call, and come to find out when I finally got to talk to the right person, that there was something missing, but they didn't tell us. The word was it was just a process, that we've got all your stuff, but when I finally did nail down somebody that could tell me, they were missing a piece of information, and that's why it was being held up, and nobody knew. So anyway, we got it resolved, but it just seems like sometimes one hand doesn't know what the other was doing up there.
And somewhere, if you look deep enough, somewhere that statute says they have to respond to that license request in a time frame. There's a time frame there somewhere.
I'm sure.
Now, there's this axiom of law that says failure to object timely is fatal, which means if you don't.
Yeah.
I found this out the hard way. That like most lessons in life.
Yeah.
Filed some. This was before I was an attorney. Sometimes I got into some lawsuits and filed an action against the government, and the government had 60 days to respond. So day 61 come around, and I thought, boy, I got them. They didn't respond. I actually didn't get to court till like day 95.
Yeah.
And the important thing I brought, hey, they had 60 days to respond. They did not. You know what the court said? He looked at me and he kind of smirked a little bit because he knew I was a pro se and not the brightest guy in the world.
Yeah.
He said, well, unfortunately for you, by not filing an objection, if that's the way you feel, you should have been in this court on day 61 complaining about it. He said, because you have not, you have acquiesced by silence. He said, you have essentially forgiven them for all this time for not filing it by not objecting to it. So failure to object timely is fatal. At day 60 in 1 hour, I should have been in court saying they're late. I want it dismissed or something like that.
Yeah.
That's what he was telling me. I've never forgotten that.
Never forgot that lesson.
So in your case, they can do it forever, and when they finally give it to you, you don't have any remedy because you didn't object.
Yeah. Yeah.
Should it be that way? I don't know. It makes sense, but maybe not.
Yeah.
So it is. Now, suppose like this one case where I got a facility kind of making people think that if they hire certain people, their loved one's going to get less care.
Yeah.
Can get picked on or something like that.
Yeah.
How about I go to our representative Clay Doggett?
Yeah.
This is a state organization, TennCare. And TennCare has these facilities contract with TennCare to do it.
Right.
I say, listen, we got TennCare's a system, and TennCare's paying a facility to care for people like the program is supposed to do.
Right.
But the facility's a little bit rogue, and they're scaring people with this rhetoric in the halls, and where there's not of record or something like that. And
right.
say, why could you please inquire for me you know, or involve the 10-care ombudsman and say, would you please look into this and see if that's going on?
Right.
Because now, I've just put it in your court because you have to take an interest in this because this is,
Yeah.
you're a state representative, this is a 10-care system, and the people that work for 10-care are out of line.
Yeah.
So you need to look into this. I mean, I can do that. I haven't done it yet, but I will.
Oh, yeah.
One of these days I will. I mean, there's several remedies I can do. But, you know, I like to get my client eligible. And so that's the goal.
Always.
If I can get them eligible and they've done some things a little bit sideways, you know, I'll wait for the perfect case to pull one of those triggers.
Sure.
But
Sure.
you know, it's like pick your battles sometimes.
Sure.
Can I do it? But yeah, I don't want to spend I mean, there's too many to pick over there.
Right.
So anyway, I love doing it. I love the eligibility process.
Sure.
Because everybody's different. You know?
Yeah.
And the same thing with trust planning, what we do for folks. You know, I met with quite a few, probably a dozen people in the last 2 weeks that we are going to do trust plans for, and they're like everything's different.
Oh, yeah.
Everybody's different, and that's just such a thrill for me because it's it's not just boilerplate stuff we crank out. You know, I mean, when I do my drafting, I have to sit and I look at my notes and when we talked about what their concerns were and things we want to have done. You know, they got kids, and there's something wrong with one of the kids that they.
Yeah.
You know, you can just imagine we
Yeah.
were talking about when they want to deal with their assets or how they get it, or how they want some people not to get them.
Yeah.
How they use them, and you know we can fix all that stuff, but it's unique. Everything's unique.
We've probably covered this to some degree before, but Stan, should everybody have a trust?
Well, when people ask me that question, or say, "Do I need a will or a trust?"
Yeah.
I'm going to tell you right up front, my answer is biased.
I understand.
I'm a big fan of trust because they're so versatile and
Right.
they do so much more than a will do. Now, I certainly think you need something opposed to nothing.
Right.
And I think a will is a step in the right direction, but it's only a step or two.
Yeah.
I think if you want to really protect things, really make sure things get distributed the way you want it distributed,
Right.
without it being challenged, without it being sidetracked, without negotiating a deal and giving some bad actor some of the money just so they'll go away, that sort of thing. A trust is your best bet because it's a heavy document and it's very much enforceable.
Right.
Wills are a little more, what's the word I'm looking for? Nebulous, a little more loose as far as what they can enforce and what they don't.
Right.
There can be challenges in probate court that are really have to be entertained. You know,
Yeah.
we have strong no contest clause in trusts, which are not enforceable in a will. I mean, you can put them in a will, but they won't enforce it. But you can put these, you know, saying, hey, here's your inheritance. If you don't like it and you want to complain about it, then you don't get anything. The language is you take as if you predeceased.
Yeah.
Somebody else gets it. That's an incentive, or at least a deterrent, to challenge it.
Okay.
And when when people talk about inheritance, you don't have a right in it. You don't have a right or an entitlement in inheritance.
Yeah. Do you want
It's
to take
just
a
not-
phone call, by the way?
Sure, is there one there?
Okay.
I didn't hear it ring.
Well, I've got the ringer turned off. It
Oh,
just
okay.
lit
Sure.
up here for me. So let's take a phone call.
Okay.
Hey, good morning. Okay, I think you got it. All right, we'll rehearse that. Okay. There. All
Okay,
right.
there's a lot in there.
A lot in there.
And a lot of it, the assumption is not exactly how it works.
Okay.
I mean, there really is no transition from Medicare to Medicaid.
Okay.
What you have is Medicare will pay a certain amount of rehabilitation, either in a hospital or facility, and then it will terminate.
Right.
But it doesn't transition to Medicaid because if you get a lot of people talk about, they say they're 100 days on Medicare, right?
Right.
Well, it's up to 100 days, but they will terminate at some point for
Yeah.
some reason. It just is never more than 100 days.
Yeah.
They can terminate early, but if they think you rehabilitate,
So that care ends.
that care comes to an end.
Right.
Now, you don't just go into Medicaid after that.
Right.
Now, if you still need to be in a facility, like a long-term care facility, then you're medically needy for that. But now you got to qualify for Medicaid.
Yeah.
Now, one thing she said that is correct. If you see that coming, okay, somebody's in the rehabilitation window that Medicare will pay for, and you're 20 days into it. It looks like you're going to be there for 60 or some days.
Right.
Now it's a good time to start doing what we need to do to get them eligible for TennCare, so that if they get the discharge date of Medicare, they will say, okay, you're at discharge, but you still are not rehabilitated enough to take care of yourself. You need to go to a facility
Right.
for some level of care, right? Well, doing it ahead of time, now we're ready to go into the facility, and now we can apply for TennCare right away.
Right.
So there is an advantage to doing that early. I mean, if you don't, you go in there, now you're going to private pay. Okay. Now there was something about if they can't have a bed to put somebody, who's responsible for that? Now it's not. It doesn't. It's typically never a family member. The responsible person is the individual that's in the hospital.
Okay, that's what I was going to get to. The second part of her question really was who is responsible for, I guess, the payment of the care.
A person that's POA, financial liability never imputes upon a person because they're the power of attorney.
Okay.
I mean, you couldn't be a power of attorney if that was the case. You couldn't be an effective one. You can make those decisions. They can never impute that any debt or money owed to you or liability simply. I mean, unless you breach the duty and do something
Right.
stupid. But I'm not talking about that. Most
Right.
people know what to do, and so that's not an issue. Now, that does lead into something that she didn't say that I think people misunderstand, and that is, if you are in a facility and you are applying for, if you're in a facility and you're private paying and you quit private paying, they can boot you out. You know, it's like anything else. So you're not paying the
Right.
service, they can get rid of you. It's called involuntary discharge. And the only thing they have to do is give you a 30-day notice. And in that 30 days, you could cure it. You could pay the bill and get caught up and it goes away, right? But
Right.
after 30 days, they can say, come and get them, or they can put you out. If you are in a facility and you have applied for TennCare, or already on TennCare, right? Or just applied, they cannot kick you out. Okay. Let me put it this way. They can kick you out, but they have to place you with another facility.
Okay.
Now, which they usually don't do because, if they do that, it's like, well, then the other facility is going to get the TennCare payments. We might as well keep you and get the TennCare payments.
Right, exactly.
But they cannot boot you out. Some people are afraid that if you apply for TennCare, they're going to kick you out.
Yeah.
I mean, that is a serious crime if a facility wants to kick somebody out that's got a TennCare pending application.
Yeah.
Or if they're even on TennCare. Now, sometimes they will boot you out because maybe you're a difficult patient.
Oh.
And they don't have the facilities. Let's just say you're just a mean person, or you're dementia or whatever makes you a real mean person, and you're wild and you throw things. You kind of need to be in a somewhat lockdown or a little more secure facility, right?
Right.
And this place doesn't have it. Now they can discharge that person, but they have to put them in another facility that
They have to find a place that can handle it.
that has those sort of
Yeah.
I don't know what I want to call it lockdown, but more secure that prevents that. You know what I
Right.
mean? So yeah, they can. You can do that, but it's not really kicking them out. They're not terminating their care. They're just switching where they're getting the care.
That's interesting. And I guess kind of vaguely remembering going through some of this process when we talked to a facility for my father-in-law's care, it seems like there were questions at the application or the process of admitting who's going to be responsible for paying for this. I mean, that's kind of a question that comes up.
Yep.
And so my thinking is okay, if I'm not responsible and the person being admitted is responsible,
That's the responsible party.
but they still ask whoever's doing the admitting who's going to pay for this.
That's right. Now, that's another problem. That's another crime associated with that I think people ought to know.
Yeah.
Code of Federal Regulations, which is a lot of things,
Yeah.
mostly Title 42.
Right.
And there's a million of them.
Yeah.
And one of them comes up from time to time. And it's one of the unique areas of law I've never seen in an area of law anywhere else in all of law. And that is, a facility is prohibited to require a third party to guarantee payment. Okay?
Mm-hmm.
So let's say, my children want to put me in a nursing home.
Yeah.
Put me in a nursing home, and we say, yeah, we're gonna pay. But they say, I want you, the child, or somebody else in the family, to sign a guarantee note that you're gonna guarantee payment. They are not allowed to require that.
Yeah.
And that statute goes even further. It says they are not even allowed to request it. Now,
Interesting.
here you have a statute that says you can't even ask for it.
Yeah. How
I mean,
about that?
I get that don't require it, but you can't even request it.
You can't even ask it.
I've had that happen. I've had somebody come to my office, an administrator from a facility, remain nameless,
And-
brought their attorney with them.
Yeah.
And they were talking about something like this, and they said, "Can we get a letter of guarantee?" And I said, "I'll have the applicant, through their power of attorney, give a letter of guarantee." Because we were confident in what we were doing. We said, "Okay." Well, the very next day, I get a note from the attorney that says, "With that guarantee, I want to modify that. I want the children. We request that children sign one in their own individual right."
Yeah.
And my response was, "You know what? The deal's off the table now. I'm not breaking the law for you or anybody else.
Yeah.
That's a crime. I'm not supporting it. You're committing a crime just by asking it." Of course, they didn't have anything. They didn't know what I was talking about. I didn't cite the CFR because I just thought I'd let them sweat. Not my job to point out their mistakes. I just said, "You know what? You're committing a crime by asking for that, and I don't want anything to do with it. So don't talk to me again. Don't come to my office with your attorney again because you're asking me to commit a federal crime, and I'm not doing that."
Yeah.
Neither is my client. Now, my client can file a note saying we guarantee payment, and they can file that through their POA because the POA is standing in their shoes making the guarantee.
Yeah.
So the person responsible can make that guarantee. But when it comes to, now this isn't everywhere in law, this is just long-term care.
Yeah.
A long-term care facility absolutely cannot require a third party to guarantee either payment or continued payment. So they can't kick you out if you can't pay.
Yeah.
And another thing, these facilities that say, we're just private pay.
Yeah.
Well, they say that. Now, they better have a pretty good vetting process because if you go in there and you run out of money and you apply, they can't kick you out and say, "Sorry, we don't take 10 care. Now that you're applying for 10 care, we're kicking you out."
Yeah.
That's a crime.
Yeah.
Once you apply, their hands are really tied.
Yeah.
It makes sense. I mean, if somebody applies because they're trying to get care and your solution is to wheel them out on the sidewalk and say, "Come pick up your dad." I mean, really?
Yeah, that doesn't work.
No, I mean, and that's why when we first started this, I made the comment that if you take 10 care patients, you get all the rules that go with it.
Yeah.
So in my humble opinion, you damn sure better know what those rules are because you are bound to every one of them. And if you don't know what they are, I'm going to hold your feet to the fire on them when I need to.
Yeah.
Because that's what makes it work.
Yeah. Some of the conversations I've had with you makes me think that the facilities ought to have someone who is extremely well versed in all of this that works for them.
Most of them have a legal department. And if it gets there, they usually kind of get it.
Yeah.
But what I'm talking about is the administrative level at the facility. They don't. They don't. I mean, if you do, kudos to you. I'm not talking about you. I don't know which ones you are, but if you do, great. You're doing a great job. You're doing what you should do.
Yeah.
Being familiar with the rules that govern how
How this works.
How you administer care.
Yeah.
I'm not talking about the care like bringing food and giving prescription drugs. I'm talking about how you operate the facility to take care of people.
Yeah.
There are a lot of rules on that. I mean, everybody, they said, well, we want to sign up for 10 care because that's guaranteed payment. The state will pay us. Not always right on time, but they will get our payment. It's guaranteed payment. But there's other rules that you have to comply. And they often don't understand that. And I have to let them know, and then I'm the bad guy.
Well, we've had some good stuff here this morning.
Yeah, well,
we're winding down
we
on
are.
time, and there's some things I'm sure you want to remind people of.
Certainly. We have another seminar coming up. It's July 19th, which is a Saturday. So I guess that's a little more than a month out. Where are we now? The 12th or 13th? Yeah. 13th. So we're roughly a month away, and that's going to be over in Pulaski, right beside my office at the Star Theater. We're not doing the American Legion there, but they're just a couple blocks apart. We're right on the square. We call it Will's Trust in the Nursing Home, and that's what we're gonna talk about. It's a Saturday seminar, so it starts promptly at 10. We actually have quite a bit of sign-ups for it already, but there's plenty of room.
Yeah.
With this theater, we got a lot of room to put people. It's newly remodeled and pretty good seating and stuff like that. So, if you want to come to that, contact my office, Pierchoski Estate Law, Pierchoski Elder Law at 931-363-7222. And I had a client visit me this week that said I didn't say my number enough. So I'm going to say it again, 931-363-7222. Or you can go to my website, it's Estate Plan Stan, ESTATE, planstan.com. And there you can get the phone number.
Yeah.
Or you can ask a question by email or RSVP online.
Sure.
Or you can look at my calendar and see when my seminars are. And the next one coming up is that one on July the 19th.
Awesome, good.
I'm also available for private discussions. You know, we do this show every Friday, and we welcome the call-ins, like the caller today, to answer questions. By all means, you got a question, throw it out there. Let's
Absolutely.
find out. You know, let's play it out. If I don't have an answer, I'll get one. So.
Yeah. Awesome, good.
So
Stan
again-
Pierchoski, everybody. Pierchoski Estate Law, located in Pulaski, Tennessee, on the square, right next to the Star Theater. A beautiful. By the way, the Sundrop Festival's this weekend.
Saturday.
Saturday.
Yeah, it sure is.
I've heard a little bit about that.
They got a lot of things planned. They got a big, THP has a great big mock accident. And the theme is distracted driving, which is what, texting, right?
Oh, yeah,
And
yeah.
they're gonna, we have, some of our actors at the theater are playing the hurt people, and they're gonna,
Oh.
and they have, one of them's gonna have a big bullhorn announcing what's going on, what they're doing now, why they're doing this. It's gonna be a pretty cool, the theater's acting as a hub for them to keep their equipment and go there when it gets cool, take the injured people like it's the hospital, stuff like that. So it's gonna
that's
be
neat.
educational.
That's neat. Stan Pierchoski, everybody. Thanks for coming in again today.
Always a
And,
pleasure.
We'll see you next Friday.
We will. Right on the money. Right on the money, and that clock is about